Okay, we're going to talk about this chapter called Relationship Between Federal and State Government. Wordy, but what are we really talking about? We're talking about when both the federal and the state governments are acting and which issue or issues we need to be looking for. A lot of times, not all, but a lot of times in this kind of case, again, this is all reading comp and issue spotting, because a lot of times it doesn't say the name of one of these issues in the call of the question. We have to figure this out from the facts. This is all issue spotting, and while you know, you're probably sick and tired of me saying it, this is all reading comp and your ability to discipline yourself to slow down in the facts and ask yourself, what's the issue? What's the issue? What are they actually testing me on? Issue spotting, what's the issue? So we have a couple of different concepts here. We'll go over one at a time like always. Get comfortable with what each is, and then you'll see how they play together. First issue in this chapter will be the Supremacy Clause. Pretty straightforward, the Supremacy Clause. You have a state law and a federal law, and they're conflicting. State law conflicts with a federal law. Who always wins? Got it. Federal. The federal law is the supreme, from the Latin, supremacy, Supremacy Clause. The federal law is always the supreme law of the land. How do I know I'm doing a Supremacy Clause question? Duh, there's at least a state law and a federal law in the same hypo. And one is basically saying you can, and one is basically saying that you can't. Yes versus no, allow versus prohibit. That's a conflict. And if there's a conflict between federal and state law, the federal law will win under the Supremacy Clause. So again, I know this is going to sound stupid and simplistic, but this is the whole mother lode right here. You reading a hypo, you go to question number 30, 35, whatever it is. The hypo is like 8, 9, 10 lines. You're thinking, oh my God, I can't read this. This is going to be too dense. And you start doing that one finger skimming where you want to just skim what's going on and you get to the bottom. The answer choices are just as wordy as the hypo. Most of you know. Sometimes in subjects like con law, the answer choices are a paragraph long. Well, 4 paragraphs, sometimes the answer choices are longer than the actual hypo. So your ability to kind of fly through the facts is only going to hurt you because now you even have more to read in the answer choice. What's the point, John? The point is if you slow down in those 8 or 9 or 10 lines and say, wait a minute, there's a state law. Okay, they're saying you can do something. Oh, wait a minute, then there's a federal. Okay, so by the time I get to the bottom of the fact pattern, if I've determined from my reading comp, there's a state thing and there's a federal thing. There's a federal and there's a state. Oh my God, there's 2 laws. Most of these questions just have 1 law, state or federal. But if I get a hypo that has both a state law and a federal law, the bells and whistles, ding ding, should be going off in my head saying, wait a minute, I could be doing a Supremacy Clause issue. And that's why I'm always yelling to dumb everything down into plain English. The state law is saying you can do this. The federal law is saying you can't do this. Oh my God, you can, you can't. Jesus, this is a Supremacy Clause. Because you don't want to go down in the answer choices before you know that, because you'll also have answers talking about commerce, due process, equal protection, etc. And those answers will look good. They're wrong because they have nothing to do with the Supremacy Clause issue. Connect the dots. Know what your issue is so I know what I'm looking for. Under the Supremacy Clause, by definition, there has to be at least 2 laws in the hypo, a federal and a state. And what do? They just put a lot of BS, a lot of mush and garbage in the middle of it to throw you off. Always be thinking issue spotting, what's the issue? I have 2 laws, I'm thinking Supremacy Clause, and I know as long as there's a conflict that the federal law will prevail. What if, this is more reading comp, what if the laws, federal versus state, don't conflict? What if they're both regulating or about the same issue, but the one is tougher, more restrictive? Can a state law be tougher, more restrictive than the federal law? The answer is yes. Can it be less tough, less restrictive, more lenient than the federal law? No. Why can a state law be tougher, more restrictive than the federal law? Because what power does the state have that the federal government does not have? The police power, excellent. The 10th Amendment, the police power. So there's a concept called the Supremacy Clause, that's over here. Federal versus state, there's a conflict. One says yes, one says no. Supremacy clause, federal law prevails. Over here, there's something called the 10th Amendment, states' rights. 10th Amendment and states' rights, the state has a police power. A state can pass any law as long as for the health, safety, and welfare of its citizens. Health, safety, and welfare. And when can a state law do that? When can a state pass a law like that? When it doesn't conflict with a federal law. State has a police power. Police power is a synonym for 10th Amendment, states' rights. It literally says in the Constitution, 10th Amendment, whatever powers are not given to Congress are reserved to the states. So in a previous chapter, we talked about the list of the congressional powers. If it's one of those things, is Congress the one that gets to do that? Yeah. If it's not one of those things, can the state pass a law about whatever it wants? Yeah, because it's not going to conflict with a federal law. Reading comprehension. So, how will I know if there's a conflict? Well, again, one law is going to say basically, you may, you're allowed, we're allowing you to do this, and one state law, other law is basically going to say you can't, you're prohibited, you're not allowed to do it. There's literally a yes and a no, you can or you can't. But what's an example, John, when there's a federal law and a state law and they're not conflicting, but the state is just being more restrictive? Here's a stupid hypo. Let's say, God forbid, because of all the bacteria now in food, right? You buy stuff at the grocery store, there's a lot of E. coli bacteria. You hear about all kind of, God forbid, bacteria or diseases that can get into food now. So if the FDA, Food and Drug Administration, FDA, federal, puts out a regulation that meat, beef, needs to be cooked 350 degrees for 30 minutes. That's what will extract all the bacteria from the meat. So the FDA puts out a regulation saying that for meat, you need to cook the meat at 350 degrees for 30 minutes. If you're in some place like Oklahoma, no offense, I love you guys, there's Sooner country out there. So if any Sooners are watching, go get them. So if you're in Sooner country, maybe you know, I don't even think there's any vegans in Oklahoma, right? Everybody eats steak 3 times a day, right? You love steak. It's Sooner country, tough Midwest. You have steak for breakfast, lunch, and dinner. No offense. So the Oklahoma is going to say 350 degrees. We know meat. We know beef. We know what it takes to cook and grill and barbecue out here. 350 degrees for 30 minutes, that's not going to get it done. That's like rare out here. You need to cook the meat at 400 degrees for 45 minutes. That's what's going to get the bacteria out of the meat. Everybody knows that. So the state of Oklahoma says, here, we're going to make sure that you cook the meat at the 400 degrees for 45 minutes. Can the state of Oklahoma pass such a law? Yes. Are they conflicting with a federal law? No. They're just making that regulation tougher, more restrictive. And why is the state of Oklahoma doing that? For the health, safety, and welfare of its citizens. Can they do that? Yes, they can. Yes, they can. Can the state of California, where most people are vegans, they're eating okra and God only knows what they're eating out there. I love you in California. I love you. I love you. I'm just kidding. Haha. But in California, you have more vegans. They want to make a law even less restrictive than whatever they want everyone to be a vegetarian. Can they do that? No. But they can only make the law tougher or more restrictive, not less so, not more lenient. That's called reading comprehension. So if there's a conflict, we're talking supremacy clause. If the state law is more restrictive, then we're talking 10th Amendment state police power. Get your magic markers out. Is there a federal police power? No. N-O. If you fall asleep after everything I say after this moment, okay, but the one thing you got to get out of this little chapter, there is no federal police power. Congress cannot pass a law for the general welfare, for the health, safety, and welfare of its citizens. They cannot. The power doesn't exist. There is no federal police power. Comma, colon. We talked about in another chapter, can Congress tax and spend for the general welfare? Yes, but that's because those are specific enumerated powers, taxing and spending. But if Congress just said, we want to pass a law because we think it's just going to benefit everybody, and it's not one of their enumerated powers, can they do that? No, because Congress has no federal police power, does not exist. Does the state have a police power? Yes. Keep that separate. That is huge. So when you see an answer choice that says Congress can act under the General Welfare Clause, there is no such thing. They can tax and spend for the general welfare, but there is no federal police power. Keep that separate. So if I have another hypo that's only talking about a state law, state green passed a law, state yellow passed a law to do blah, 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 and they're always, like I said earlier, going to tell you the purpose, the intent of the law, but you read the hypo and there's only a state law. There is no federal law. And it doesn't look like any other issue. Can a state pass a law when there's no mention of a federal law, especially if it's for the health, safety, and welfare of its citizens? Yeah, because what power, what answer should I be looking for? What power does the state have? 10th Amendment, the state police power. State can pass any law, health, safety, and welfare for its citizens, as long as it doesn't conflict with a federal law. So if you've only got a hypo talking about a state law, I'm not saying it's the answer all the time, I'm just saying, okay, well, if I'm doing only with the state law, then I don't have to worry about anything regarding supremacy clause, because supremacy clause isn't going to be an issue if there's only one law in the hypo and it's only by the state. Good? Good. Next, there's a rule called the commandeering rule. The federal government cannot command, commandeer rule. They cannot command the state to do anything. Remember, this whole chapter is about the relationship between federal and state government. So we talked about supremacy clause, federal and state with a conflict. We talked about federal and state when there's no conflict, but the state can be tougher. Now we're saying, what if Congress passes a law and requires the state to do something? Congress passes a law obligating, demanding, commanding a state to do something. Unconstitutional because it violates the commandeer rule. Commandeer rule. Now, this is one of those rules that I think is great and or difficult because one word, literally the word command, require, obligate, will change the whole hypo. So you can have a paragraph of a fact pattern, but it really is going to come down to, as I say in con law, what is the government doing? State or federal? What is the language of the statute about? And if you can slow down, reading comp, slow down in the facts, you see that the statute said the word requires the state, obligates the state, commands the state. That's the commandeer thing. It's required. They can't do that. Now I know what answer I'm looking for. And so this is an example of some other ones we'll talk about in another con law chapter where one word will change the whole question. If you can see it in the facts, you can't get the question wrong. It's easy. If you read too fast, you're giving away a free, stupid question. Slow down. Commandeer rule, Congress can ask the state, Congress can work with the states, they can work together, but what can Congress not do with the state? Command. They cannot require a state to do anything. Keep that separate. Excellent. So again, just so far, take a quick break. Here we go. So if I'm reading a hypo and I see, man, this is really tough to read, John. This is a lot of dense stuff. And I get to the bottom of the hypo and I'm still not sure which one of these things the whole thing is about. What do? Dumb everything down. Occam's razor from the beautiful Scully. What did she say? All things being equal, the simplest explanation is always the correct one. If you only figured out that this whole hypo was about the state and the federal government. The state's doing something with the federal, Congress with the state, state and Congress. There's something going on between those two types of government, the federal and the state. At least you know you're doing some sort of question about the relationship between state and federal, i.e. your answer choice that you pick must, shall, has to be about the issue of the state and federal government acting intertwined, the relationship between federal and state. So let me get this straight, John. If I could read a hypo, and I still really don't know what particular rule or power I'm dealing with, but I know the answer must have something to do with Congress and state, state and Congress, I could literally just shut up and pick the answer talking about state and Congress. And you'll see how stupid a lot of the other answer choices are. Yes. Am I saying you're going to do that on all the questions? Obviously not. But some of these questions are just written so densely, you're really kind of scratching your head wondering what's going on, so then you look at the answer choice too fast. And what do you do when you do that? You pick the weird, stupid answer that you know is wrong. You don't go back and say, what are the facts talking about? Dumb everything down. This is a chapter where the questions are very wordy. You can't really get a feel. You can't get a handle on it like you can with some other things. The issue doesn't necessarily pop out. And sometimes it's very esoteric reading comp. You just say, wait a minute, this is one of those state and federal things. Let me look at the answers and find the most specific state and federal answer that relates to the facts, line it up, connect the dots. But you can't connect the dot if you didn't spot what the issue is all about. So sometimes these issues will pop out, like the supremacy clause. Congress says, federal law says yes, state law says no. Sometimes it appears very wordy, and you just said, this is one of those with the federal and state thing. Let me just shut up and pick the answer talking about the federal and state thing. You will surprise yourself as to you can steal a good number of questions that way. Next, let's talk about a concept called the Dormant Commerce Clause. Dormant Commerce Clause. There is the regular Commerce Clause, the Commerce Clause issue, the big one. Who, which branch of government acts when we're talking about the Commerce Clause? Good. Congress, federal. We talked about in another chapter. Congress has the power to regulate interstate commerce. So when I see Congress acting in a hypo, which they'll tell me, now I know I'm doing the federal, the Commerce Clause. Congress can pretty much do whatever they want. Here, we're talking about the Dormant Commerce Clause. Who is acting when we're doing a Dormant Commerce Clause question? The state. The state is passing a law. Under the Dormant Commerce Clause, the state is passing a law regulating business. They're regulating some sort of a business interest. Who's acting? State law. State government is passing a law that regulates business. And it discriminates against out-of-state business interests. A state is passing a law regulating some sort of a business interest, and that law is discriminating against out-of-state businesses. That's called the Dormant Commerce Clause, and if it discriminates against out-of-state businesses, it's unconstitutional. It cannot, the one state cannot do that. So, if I see Congress is acting to regulate how much cotton are in children's pajamas and rubber and tires and lead and pencils, etc., then I know I'm doing the Commerce Clause, and Congress can do whatever they want. If the state is acting, the state of Florida passes a law regulating how much fish can be caught and sold in the commercial fishing business. Now I'm doing what kind of a question? Dormant Commerce Clause. Can the state of Florida pass a law regulating the quota of fish that can be caught if it discriminates against out-of-state fishermen? The Alabama and Mississippi and Louisiana fishermen are now upset because they can't catch as much fish. No, that is unconstitutional. So I'll give you some tests that apply, but then I'll tell you the way it really looks. So write this down, then we'll talk about it. If it's discriminating against the out-of-state businesses on its face, i.e. right there in the hypo, then we apply strict scrutiny. Strict scrutiny. If the discrimination is incidental, if it's not explicit, it's just that the effect of that regulation would discriminate against out-of-state businesses, discrimination is incidental, then it looks like an intermediate level test. It must serve an important governmental interest, and the burden on commerce shouldn't be excessive. The burden on the commerce shouldn't be excessive. Must serve an important governmental interest, and the burden on commerce should not be excessive. So, for the literal buzzwordy thing, if I saw a hypo which said, the state of Florida passes a law and says the Florida fishermen can catch 1 million pounds of fish this year, but the state of Alabama fishermen can only catch 1,000 pounds. Are they now discriminating against the Alabama fishermen on its face? Yes. And therefore, you would either look for an answer which basically just says unconstitutional under the Dormant or sometimes just Commerce Clause. And sometimes it'll say it will apply the strict scrutiny test. You're looking for the buzzword compelling interest, etc. Most of the time, you're just looking for an answer that says unconstitutional according to the Commerce Clause. Speaking of that, not all the time, but a lot of the time, you may be looking for the phrase Dormant Commerce Clause, because that's what you know the issue is, but they don't use the word dormant. They just use the word Commerce Clause, the phrase Commerce Clause. That's not a trick. So a lot of times, even though you know you're doing a question about a state passing a law discriminating business interest, and you're looking at the answers A, B, C, D, and you're thinking, where's the dormant word? It's not there, it's just commerce. Still shut up and pick the one talking about Commerce Clause. They don't always use the term dormant. They may just use the phrase Commerce Clause. You know and they know what we're talking about, because who is passing the law? The state. So most hypos will just be state of Florida passing a law, how much fish the Florida fishermen can catch, and then the out-of-state businesses are upset and they're suing, saying it's unconstitutional. If the state law is about the regulation of some sort of a business, we're doing a dormant Commerce Clause question, and generally it will be unconstitutional if it has any kind of discriminatory effect against out-of-state businesses. Once in a while, they'll give you a question testing you on the tests, giving you the elements of the test. And if you see a statute, that's why I'm always yelling, read the statute, which specifically distinguishes or discriminates against out-of-state business, it names them on its face, then we're applying strict scrutiny. If it doesn't, sometimes if it's just the effect of the statute would discriminate incidentally. Once in a while, it'll give you the buzzword important governmental interest, but most of the time it's issue spotting. They're just trying to get you to see that you're doing a dormant Commerce Clause question. And how will you know that? Because who's passing the law affecting business? The state. And when the state is passing a law about a business, you be thinking dormant Commerce Clause, the out-of-state people are affected, it's unconstitutional, and now I know that I'm looking for an answer talking about the Commerce Clause. Whether it says dormant or not, I know what I'm looking for. When can? Most of the time, as I said, it's unconstitutional. The state can't do that. When is it constitutional? When can the state pass a law that discriminates against out-of-state businesses? When can a state pass a law that will, in fact, discriminate against out-of-state businesses? When can the state do that? When the state is acting as a, market participant. When the state is acting as a market participant, then they can. What does that mean, John? Market participant generally means when the state itself runs the business, runs that industry. They're it. The state isn't talking about the fishermen. The state acts as the fisherman. It's the state company, the state industry. The state is running the whole industry itself. If they're not farming it out, if they don't allow private companies to do it, the state is doing it in-house, so to speak. Then that says the state is acting as a market participant. It's a state-run industry. There is no private company and private businesses. How will you know? They'll tell you. So either it can say in the hypo somewhere that the state is running the industry, the state has taken this business in-house and they are running the industry. Now you know they're acting as a market participant. And sometimes they're just going to give you a hypo where it'll say something like the state is passing a law and it seems to be discriminating against out-of-state businesses. And you're thinking, yeah, this looks like a dormant Commerce Clause. They can't do that. And instead it may say, when can the state do this? When will it be constitutional? And now I know you're looking for an answer that says, when the state is acting as a market participant. You're just trying to connect the dots. When is it okay? Market participant, issue spotting, shut up and pick it. So 99% of the time, under dormant Commerce Clause, the state cannot do it. It's unconstitutional if it discriminates against the out-of-state businesses. When is it okay? When they're acting as a market participant. Buzzwordy, two-word definition. Excellent. All reading comprehension. Next, full faith and credit. The issue of full faith and credit. Little rule all by itself, one little thing. The judgment on the merits in one state must be given full faith and credit in another state. What is full faith and credit about? There's a judgment in a case on the merits in state A, then the courts in state B have to give that judgment full faith and credit. So you have a long hypo that talks about a case being resolved in state blue, and now all of a sudden something similarly is going to happen in state green. The judgment in the first state has to have full faith and credit so that the case in state B, the second case, the court must give that full faith and credit. It's basically respect. Whatever the judgment was in State A, State B has to give it full faith and credit. This is all issue spotting. So if I see a hypo about a case being resolved in one state, and now they're talking about, well, what would the judgment be in the second state? We're talking about the relationship, the respect between State A versus State B. What will my answer have to be about? Full faith and credit. That the judgment in one state must be given full faith and credit, respect in the second state. Maybe one question, full faith and credit sounds like a big phrase. You're just looking for the resolution of one case being given full faith and credit in another state. It's just reading comprehension. Good. Now let's talk about the next concept is federal and state immunity. Okay, under federal, then we'll talk about the state, keep them separate. There's a couple of rules to know about when the federal government and or when the state government get immunity. Who can do what to whom? Remember, the whole point of this conversation is the relationship between federal and state government. Reading comprehension. So, federal immunity. When, in which cases does the federal government, are they immune from suit or any problem? We're talking now federal immunity. A state, the states, cannot sue the federal government. The federal government are immune from suits by the states. The states cannot tax the federal government. The federal government is immune from being taxed by the state. People who work for the government can be taxed. Individuals, private people, private businesses can be taxed even though they work for the government. So again, that's why this all reading comp. Can a state tax the federal government? No. But if you're a person who works for the government, can you be taxed? Can John be taxed? Yes. You're always looking for the difference between, is the state taxing the federal government or are they taxing John, private citizen? Then, even though I work for the federal government, I can be taxed myself individually, reading comprehension. An individual cannot sue the federal government except when the federal government consents to the suit, when they basically pass a statute allowing an individual to sue them. There's always these individual cases. Sometimes in these catastrophic, God forbid, you have these cases, God forbid, there's a plane crash or some sort of other situation where if the federal government could be at fault, there's specific statutes that would allow a suit against the federal government. So, generally speaking, definition, buzzwordy definition. Can an individual sue the federal government? No, federal government has immunity. When could John sue the federal government? When the federal government consents, which means they basically pass a statute allowing it in these particular circumstances. And how will you know? They'll tell you. Can a state sue the federal government? No. Can a state tax the federal government? No. Can a state tax a person, an individual who happens to work for the federal government? Yes. That tax has to be done individually. So federal immunity, obviously imagine federal government, big shots. They pretty much can't be touched, except in certain little circumstances. It's all reading comprehension. Get comfortable with what these fact patterns look like, and it's actually not that bad. Now we'll talk about the state immunity. When is the state immune from action or not? State immunity now. The federal government and other states may sue a state, okay? Different. Federal government and other states are allowed to sue state A, okay? No immunity from suit there. The federal government and other states are allowed, may sue an individual state. The federal government may not, cannot tax a state if the tax is applied to a government activity or function. So the federal government cannot tax a state government, if that tax relates to the government in their governmental function while they're doing their job as a governmental function. However, the federal government may tax if it's applied to a proprietary business, like an individual who runs a business that happens to be on state property. So hear me out again. The federal government cannot tax a state if the state is acting in their governmental function, in their governmental business. can the federal government tax John even if I'm working on state property? The answer is yes. The answer is yes. So how do these questions always come up? What if John has a little gift shop, those sundry shops, the little gift shop inside the state courthouse, and I'm selling the newspapers and the magazines and the king-size M&Ms, all that stuff? Can the federal government tax the state courthouse, the state government, and obviously what's going on in a courthouse or a governmental building? The government function, the government's doing their job. No. But if I have a private business inside the state courthouse building or the state governmental building, it's John's gift shop. Come in and buy Jet t-shirts and X-Files paraphernalia and your M&Ms and your newspapers, etc. Can I be taxed if it's John's private business, proprietary business? Yes. So again, reading comprehension. The federal government cannot tax the state entity, the state government, while they're doing their governmental function, but they can tax an individual, a proprietary business that happens to be on the state property. Reading comprehension. Excellent. Similarly, again, we said in the earlier one with the federal immunity, a state cannot tax the federal government, but can the state tax people who happen to work with the government or on government property? Yes. So again, if I have the opposite, the little sundry shop or the little gift shop that happens to be in a federal courthouse, but it's my business, a private, excuse me, can they tax John the individual? Yes. So you're basically looking for these hypos where the tax is either affecting the governmental entity or it's a private business, John Inc. Keep them separate. This is all reading comprehension. Keep the federal immunity issue separate from the state immunity. Get the little card, get it down on your notes. They're wordy hypos, I agree, they're wordy hypos, but once you can keep a couple of these rules separate, then generally everything is okay. This is an issue, this relationship between federal and state government. This is one of those issues that, again, like with separation of powers, the hypos are wordy. It's not like 2 + 2 is 4. It's not like a tort or a crime where it's an elemental definition. It pretty much is okay if you know the rule. These require patience in the facts. But if you can focus more on the issue spotting than all the minutia of law, and then when you go into the answers, you know what you're looking for. And if I say, I think that's a supremacy thing up there, so I have to look for the supremacy thing down there, the state has a police power, federal doesn't have police power. Is the state and federal law conflicting, or is just one tougher than the other? Get comfortable, and if you absolutely don't know what the heck is going on, you just say, this is one of those federal and state things, because I see in the facts, Congress is acting, but the state is acting. There's a state and federal something. There's a state and federal something going on in this fact pattern. So in the answer choices, what am I looking for? Something talking about federal and state. Connect the dots. Dumb everything down. Occam's razor from the beautiful Scully. All things being equal, the simplest answer is always the correct one. Connect the dots, shut up and pick it. Go get them.